Disney and Bob Iger have continued to dig themselves in deeper and deeper and deeper, as now they're embroiled in two separate lawsuits with the state of Florida, particularly with DeSantis and the DeSantis appointed district, the Central Florida Tourism Oversight District, which is the successor to Reedy Creek. And in this battle between Disney and DeSantis, what they don't realize they're digging in on is potential criminal charges. Yes, they actually risk criminal charges as they go deeper and deeper into this battle, and as they really bring attention to things that no one was paying attention to. So today I just wanted to run over some potential state charges that can be brought against individuals within the Walt Disney Corporation, or perhaps potentially Bob Iger himself. Now we're going to discuss all of this on this channel. Of course, I am Andrew Esquire. This is a legal mindset. We teach you to be your own judge. And I decided to do this today because a lot of people, when I talk about securities fraud or bond fraud, tax fraud, people think federal charges, and perhaps rightly so. They think that maybe Joe Biden is not going to prosecute individuals that are going after his political enemies. So Ron DeSantis, strong in the Republican Party, obviously opposed to the Biden agenda. Whether or not he runs in this next election cycle, that's kind of neither here nor there. He's opposed to Biden. So people say, look, the feds aren't coming for Disney, that they're not going to help on this. But you don't need to turn to the feds if you're looking for criminal charges. No. There are state level potential criminal charges that can be brought for some things that potentially have happened here. Now, I want to start this out with a couple disclaimers, because unlike other folks that have talked about this subject, I try to be 100% factual with you and 100% clear and transparent. I have never been a state attorney or a public defender, so I would not call myself an expert in criminal law. That's not what I do. So let me just throw that out there right now. What I specialized in was special districts, which happens to be what the primary lawsuit, the state lawsuit, and to an extent the federal lawsuit are about. But also, I was in-house counsel. And when I was in-house counsel, I was in risk and compliance. And one thing I know all about is risks. And when I talk to corporations or my companies, I would say, hey, look, here are the risks. So I'm approaching this from what I know as a risk analysis, saying, look, I'm not saying these are going to be charged. In fact, these may never be charged, right? But here are the potential risks. So not saying any of these happened, but they are risks, huge risks, and they carry criminal penalties. In fact, severe criminal penalties. I will also say this is very, very important, and I strongly believe in this, whether or not you believe somebody is nice or naughty, whether you like them or not, whether they're woke or whether they're based, it does not matter. Everyone is innocent until proven guilty. So Disney, Iger, officers of the Disney Corporation, former officers of Reedy Creek, they're all innocent until proven guilty. And most importantly, before any charges can be brought, there needs to be evidence. So anything I mentioned today, they would need to go out and find the evidence. I don't have the evidence. I don't have the proof. I'm just saying these are risks. So just understand that. I am going to tell you statements that have been made and things that have happened that have made me think, this is a reason why I would identify this as a risk. So understand, when I'm identifying it, I'm not just pulling it out of nowhere. I'm saying it's based on things you've said, but these state attorneys would actually need to go find evidence, right? Documents, records, emails, phone conversations, text messages that back this up and provide evidence to bring these criminal charges. But with those disclaimers, and now that we've been 100% transparent on this channel, let's get into Disney's Florida criminal risks. And I know we all love the Gators. So first of all, we're going to start with failure to pay taxes or evasion of tax. Now, and this is in Florida statute. And by the way, whenever I put FS, that stands for Florida statute, 839.13. Now I'm going to read these statutes. Sometimes I'll paraphrase, sometimes I'll read them in full, but I'm going to translate from legalese. So don't worry, I am here to put this in a way that you guys can understand. So this is a catch-all statute, 198.40, failure to pay tax or evasion of tax. So any person required under this chapter to collect, account for, and pay any tax imposed by this chapter who willfully fails to collect or truthfully account for, pays over such tax, or who willfully attempts in such manner to evade or defeat any tax imposed by this chapter or payment thereof, shall be guilty of a felony to a third degree. So what are we talking about here? Look, if you're somebody who has to collect a tax, i.e. a government, i.e. Reedy Creek, and you did not do that, yeah, that's something, that's a risk. And what's one of the taxes we've been talking about? Well, Bob Iger keeps saying that, well, Reedy Creek is Disney and Disney is Reedy Creek. He said it over and over and over again. If that's true, then those bonds, remember the $1 billion of bonds they issued, billions of dollars of bonds? Yeah, they would need to pay taxes on those. Those would actually be taxable bonds, not tax-free bonds. So they would owe back taxes on those bonds. And if they knew that this entire time, then they should have been collecting that. That's a big one. That's a huge one. Also, if we look into the books, did Disney really pay everything they should have been paying? And are they going to continue to pay everything they should be paying? Once again, you need evidence to find that, but if any of those violations were there, 198.40, you've got failure to pay tax, and you've got individuals, including folks of the former Reedy Creek, that might be, or let's say risk, a felony of the third degree. And don't you worry, I'm going to explain all these different levels, felony of the third degree, what that means in terms of jail time at the end of this video. So hang around. Next, we've got falsifying records. Now, this is a big one. I am going to paraphrase this, but this is very, very, very broad. It is Florida Statute 839.13. So if any judge, justice, mayor, alderman, clerk, sheriff, coroner, or other public officer, or employee or agent of, or contractor with a public agency, or any person whatsoever shall steal, embezzle, alter, corruptly withdraw, falsify, or avoid any record, process, charter, gift, grant, conveyance, or contract, or any paper filed in a judicial proceeding in any court of the state, or shall knowingly discharge, conceal, forfeit, or other forfeiture, or other paper above mentioned, or shall forge, deface, or falsify any document or instrument recorded or filed in any court or registry, acknowledgement certificate, or fraudulently alter, deface, or falsify minutes. That's meeting minutes for government meetings, by the way. Books, documents, or proceedings whatsoever belonging to any public office within this state, yeah, they're guilty of a misdemeanor of the first degree. That's a lot. And I know that's a mouthful there, but guys, there's so many potential risks here. We're talking the bond documents. So any of those disclosures in the bond documents, those were all recorded. Then you remember those restrictive covenants they put in there? Remember those 11th hour documents? Yeah, if they falsified anything there was anything that they put in there they knew was not true, yeah, there you go. There you go. If they had any minutes that they changed, anything that they altered, right? In Reedy Creek, any of those Reedy Creek documents, there you go. Also, mind you, who's at stake here? Remember, the Disney Chief Counsel was a contractor for Reedy Creek. Therefore, these duties attached to them. So if they in any way changed any of those documents in a false manner or fraudulent manner or altered them, could be problems. It's a huge risk. Any of those documents in Reedy Creek that were altered, huge risk here. This is massive, 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 massive. And this one right here is going to be one of the ones that I think is the largest risk, because Disney treating a public entity as a division of Disney, as Bob Iger has repeatedly said, oh, this is Disney, this is Disney. If they just treated it like Disney, this is going to be really, 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 really tough. This section is going to be really tough under 839.13. I would be sweating. I think this is a huge risk for them, just based off the statements that they've made so far and what we know in the cases and what's been filed and what's been disclosed publicly. All right, a false, fictitious, or fraudulent act or statement of representation. So this is another catch-all which they could be gotten for, potentially under 817.155. So this is just generally if you knowingly or willfully falsify or conceal material fact, make a false, fictitious, fraudulent statement, or make or use any false document, knowing containing any false, fictitious, or fraudulent statement or entry. And that's a felony of a third degree, much like the last one. So you can view these two, this one and the former criminal charge, is very similar. But once again, two separate options in the Rolodex of the state attorney when they're looking at this and investigating this to go ahead and say, did Disney make any false disclosures either as on the government side or on the business side? Because this comes in and hits them on the business side. So if Disney was going in there and doing anything on the business side they shouldn't have done or shouldn't have made, remember that parks entity, that Walt Disney Parks, that's a Florida entity. Yeah, there's some huge risk there. There's some huge risk there. And that will be within the jurisdiction of the Department of State. So this would fall under this particular statute. Once again, they've only got to get one. And yes, this does have a statute of limitations of 5 years, but a lot of these statements have been made, this year. So this is what's really, really concerning. And this battle's been going on for the last 2 or 3 years. I think they really need to be concerned about the statements they made in the past 2 to 3 years under this particular statute. Definitely flagging this one as a risk. This one, and this is actually a little bit longer, so I had to break this up, but this is an unlawful filing of false documents or records against real or personal property. Now remember, real property is land. It's real estate, right? And those restrictive covenants, those development agreements, yeah, they were recorded against real property. So look what it says here. Any person who files or directs to file with the intent to defraud or harass another, any instrument containing materially false, fictitious, or fraudulent statements or representations that purports to affect an owner's interest in property commits a felony of the third degree. Now, here's what happens. Pay attention. When we skip down to 3, what does it say? If the owner of the property subject to the false instrument is a public officer or employee, it ups the severity by a degree. The felony of a third degree becomes a felony of a second degree. Felony of a second degree becomes a felony of the first degree. And this is per incident. The incidence is as if there's more than one incidence of this, it can increase it. So if it happens a second or subsequent time, you see it goes in the initially to a second degree, right, under B. And then it under 3 gets accelerated to a first degree felony. So you're gonna understand, guys, first degree felony, it means potential life in prison. Okay? That's what first degree felony means. Understand that. 30 years or life. So that's what we're talking about here. This is a huge, huge risk. But there's another part of this statute, Florida Statute 817.535, that I think is very intriguing, and it defeats a massive Disney argument in their motion to dismiss the state case. Here we go. So in this, under 8A, in summary, and I'm not going to read this all, but there's 2 parts here that are huge. Number 1, anybody who is impacted, any individual person, which by the way includes businesses, because Citizens United, businesses are people, and under the statutory definition, person includes entities, right? So anybody, including businesses that have been affected by those things that were recorded, right? So by that development agreement, by those restrictive covenants, meaning any business that was within Reedy Creek, all those other businesses, yeah, they all have a civil cause of action without regard to whether criminal charges are pursued. So literally, all of those entities, all those people, they can sue civilly. That is big. That is huge. I mean, and I think you guys, you can't underestimate that. I'll just go big on this one because I think this is one where Disney is really messing up because they've opened themselves up to criminal and civil. Now, there's other civil things that can go on against Disney. That's going to have to be a separate video in terms of the risks that they face. And there's other sort of administrative risks. There's tons of other risks. This is a criminal risk, but I just wanted to specifically highlight this because the criminal statute goes out of its way to say, no, by the way, there's a civil cause of action that's opened up here. So Disney has indeed opened that up as a risk. And here's the thing. Under 1, it says the court shall determine whether an entire instrument is null and void ab initio. If it is declared void, it is removed from the database, and here's the important thing, the court may enjoin the defendant from filing anything in the official records without a court order. So there's two things here that are massive that I think Disney is going to just get absolutely blown out of the water if they're ever charged with these crimes. Number one, Walt Disney World, imagine this, could not file routine real estate documents, which they are filing all the time, regularly, day to day, without a court order. That would absolutely hamstring them. That would be a compliance nightmare. They would have to hire several extra attorneys, paralegals, just to be on that, or farm it out to a law firm, which is probably what they would do, paying the lowest bidder. That's typical Disney move. But they would have to pay extra money to go and get a court order every time they wanted to record a document, because the court's got to review it to make sure Disney is not doing anything shady and illegal. That would be insane for Disney, and it's a huge potential risk. But the second part is, and this is the important part of this statute, and I'll blow this up so you guys see it again, it says the court shall determine whether it's void ab initio. So there was a motion that Disney made saying, oh, well, because the state legislature voided the development agreement, there's no reason for there to be a state case. But this statute shows there's a reason for the state case. Just the statute alone. Now, mind you, this statute's not necessary to defeat that motion to dismiss. It's going to get defeated all on its own for a million other reasons, which I've covered in my previous video. By the way, if you're liking these videos, make sure to like, comment, and subscribe, guys. Make sure you're clicked in, ding the notification bell, because people don't always get the notices, but you want to get the notices on these. So with this means that they need the court to have this case. They need the state case. The state case must happen in order for it to be declared void ab initio, because there's these other things that the court may end up doing, like enjoining Disney from recording further documents. That's something that the court needs to consider. Hey, do we need to do that? Because that may be something that the court feels the need to do, regardless of whether criminal charges are brought. I think that's pretty huge. Next, we have withholding records from successor. This is another criminal charge and another criminal risk under 839.14. So here's a huge thing. So Disney and the Attorney General in Florida is already investigating the records issues with Disney and Reedy Creek. They're looking into whether or not Reedy Creek turned over all its documents, because it's looking like there's some missing documents and emails and text messages and other things that were not turned over to the CFTOD, to the new district. And anybody who willfully withholds records, papers, documents, or writings, well, guess what? If you mutilate, destroy, take away, or otherwise prevent the complete possession by successors, you're guilty of a second-degree misdemeanor. So, boom, another crime on the line for people that are withholding those documents. That's Disney, that's Reedy Creek, that's anybody who's holding out those documents. Next, and this is a very interesting one. This is a little bit tinfoil. This is me reaching, and this is definitely, let me just go out here and say this. This one is very much like a Hail Mary crazy thing, but it's only something that was brought up because Iger's made such ridiculous statements over and over again. Iger keeps saying Reedy Creek was Disney and Disney was Reedy Creek, and their lawyers are insisting upon this. The Disney shills are insisting upon this, right? The pixie dusters are all up in this. Disney is Reedy Creek is Disney. Okay, if that's true, well then they have a huge risk of violating 839.05, which means that anybody who's working for any incorporated city or town, which, by the way, there's two cities or towns within Reedy Creek, Bay Lake and Buena Vista, you cannot directly or indirectly speculate in any other evidence of indebtedness or script belonging to the municipal corporation. Well, if Disney is Reedy Creek and Reedy Creek is Disney, then none of those people can own Disney stock or script. If they're the same thing, then they're violating this statute. So are they or aren't they? Or are they distinct? Or are they different? I would just say now this is a long shot, admittedly. But what I'm saying is when you keep saying something over and over again, that these are the same thing, you risk putting yourself in the crosshairs of these more remote statutes that would normally never apply to a corporation. But what is Disney doing here? Now, I don't know whether Disney is owns any of the bonds that were issued. Now, that might be an issue if there's something going on there. However, I think this one is entirely because Iger made crazy statements over and over again in the earnings calls, which is places as a risk. Once again, we need more evidence, but definitely a risk. Misappropriation of public funds. This is a large catch-all under 206.56. Now, this is unlawful use of a tax. Any person who knowingly obtains, uses, or endeavors to obtain and use taxes collected pursuant to this statute, or rather this chapter, with the intent either temporarily or permanently to deprive the state of a right to funds or appropriate the funds for its own use, commits theft of state funds. If it's over $100,000, which, by the way, if we're talking about bonds, yeah, it's way over $100,000, the offense is a felony of the first degree. So we're talking about a first degree felony. Once again, life in prison. So any use of taxes that is that large, for example, if we're supposed to take those bonds that were supposed to be taxable, right? And you didn't collect those taxes and you're misappropriating them, you're depriving the state of the benefit of that tax revenue. I mean, there you go. That's something. Once again, this is something that would never come up normally, would never pop up. But once again, because Iger and Disney keep making these positions and taking these radical positions, they're putting themselves more and more and more and more in the crosshairs. Also, another thing for this is looking back at Reedy Creek's books. Are their books clean? Are their books really showing that Reedy Creek was using that money how they should use it? Or was Disney misusing that money? Something that we'll need to explore and definitely a risk. Okay, now sunshine laws. I'm going to do a little summary on these, but sunshine laws are Florida's transparency laws. And pretty much the general policy statements here, this is a very long chapter, chapter 119. I suggest that you guys don't read it all because it's very long. But just generally, here's what you should know in 119.1, that generally all state, county, and municipal records, Reedy Creek was a type of municipality. It was a subdivision of the state, are open to personal inspection and copying by any person. Providing access to public records is a duty of each agency. So everybody has to if there's a public entity, they've got to have access to it. And just because it's automated or electronic does not mean it. You have to provide reasonable access to records, okay? And you have to keep them and give them in a manner as they're stored. Right, so if they're stored as a PDF, you give it as a PDF. If they're stored as a doc, you can give it as a doc. You don't have to change the medium. You don't have to put it in a way it's not normally stored. So, for example, I would have people saying, hey, can you burn me a CD? Well, we don't really do that. So we're not burning you a CD of documents. That's not what we're doing. We'll give you a flash drive with some documents on it because that's much easier and that's how we maintain them and would normally transport them. But they've got to maintain them. And if they fail to do that, well, they're committing several different infractions. If they do it unintentionally, then it's a non-criminal infraction. It's a fine, $500, not too much. But if you do it knowingly, it's a first-degree misdemeanor. So if they are knowingly holding back records right now, and this is what the Attorney General is looking into. So this is a massive risk for Disney. Once again, first-degree misdemeanors here. They are putting themselves at risk. And this is for every single violation. Mind you, this is per violation. So this could be several violations piled up here with sunshine law violations. So what are we talking about in terms of punishment? Let's talk about the punishment here. If it's a first-degree misdemeanor, you're talking about imprisonment of up to a year. Up to a year. If it's a third-degree felony, that's 5 years. Second degree is 15. And on a lot of these, you heard me saying first degree. You heard me saying first degree felony, first degree felony. Well, that's 30 years or life in prison. Life in prison. So that's what we're talking about. We're talking about up to 30 years to life for Mickey. And once again, these are risks. These would need to be proven in a court of law. But I think because of Bob Iger and because of Disney and everything they've done in terms of statements they made during earnings calls, because the representations they made in their own legal filings, and because of the position they're taking in the media, including direct statements and indirect statements by corporate shills and by pixie dusters, they're really putting themselves in a weird position. And I think they're having huge, unnecessary, self-imposed risks of criminal prosecution. If I was their in-house counsel, I would be running around with the fire hose trying to tamp down these risks. That being said, guys, make sure you're liking this video. Leave a comment if you agree or disagree. If you consider yourself a Florida criminal expert, leave a comment below. Tell me whether you think these are good charges, bad charges. Do you have any you would add to this? Are there any other things that you would add to this? What else are you thinking about when you think of Disney and crimes? Talk to you later.